You're listening to the SMSF Academy podcast, and this is episode 30.
Welcome to the SMSF Academy podcast, the show designed to help professionals stay ahead of the curve. Now, here's your host, the man that's in the know and shows you how SMSF is done right, Aaron Dunn.
Hi there folks, Aaron Dunn here, and thank you again for joining me in this week's podcast. We are very much into the full swing of things in 2018 and have had once again some great feedback on our most recent episode, in particular the documentation that we need around taking more than minimum pension. We have seen over the past week ASIC come out and provide some information around the importance of appropriately documenting death benefit nominations. And today I have a guest, Chris Hill, where we spoke about not only the issues that ASIC raised within the formulation and documenting of those binding death benefit nominations, but more importantly, what it means for SMSFs in the context of not only documenting them, but really looking at the flexibility in how the governing rules of a fund could determine what type of death benefit nomination and the way in which that death benefit nomination may ultimately play out. We work with Chris and his firm Hill Legal, in addition to Ian Glenister within the SMSF Academy as part of the oversight to our SMSF document suite. And I think you're going to get a lot of value out of this week's podcast, like I said, where Chris and I not only go through some of the issues that ASIC raises, we look at some of the recent case law history and again, the lessons learned from that, what you as an advisor or practitioner really need to understand throughout this process, and really understanding what it is that is unique and different around the deed that you need to be looking out for to ensure that the binding death benefit nomination gives you the outcomes that you're looking for. So I hope you enjoy this week's podcast. If you do have any questions, please feel free to reach out to me. Thanks for joining me today, Chris, in this podcast. We're going to spend a bit of time today discussing ASIC's recent media release and focus on the completion of death benefit nominations by professionals and their involvement, and where in many instances I think they're finding there's a failure to correctly witness those documents. So I'd really be interested in your comments around what implications this might have more specifically to SMSFs, but we know this is far broader than the SMSF marketplace. So maybe if you could elaborate a little bit, I guess, on what ASIC is really drilling down on here when it comes to binding death benefit nominations.
Yeah, thank you, Aaron, and hello, everyone. ASIC's concern is very much focused on the way nominations are completed and signed. And I think this is a follow-on from a number of cases that we're seeing, particularly over the last 2 to 3 years, where the courts are throwing out nominations, particularly binding death benefit nominations, because they don't follow the governing rules of the deed, which specifies certain requirements for the nominations to be binding and effective. And I think ASIC is echoing some of the concerns that they're seeing out there in the market, where nomination forms are not properly signed or they're not properly completed, and it's as they say, is a red flag for closer scrutiny, where there's going to be a lot of disappointed beneficiaries.
Yeah, and that's important, I guess, when we look at in particular the blended families, and that's where we've seen a lot of the case law lessons come from, haven't we? Where it may be the children from the initial family are the aggrieved ones because of an inconsistency to the governing rules of the fund in terms of how documents have been created or have become invalid by not following what is due process.
Yeah, and I think there's, especially when you mention the blended family, that's a very interesting and topical issue. A lot of people may not be aware that when one member dies, the relationship between the stepchild and the other member ceases.
Mm-hmm.
And the ATO has confirmed in a previous determination that as a result of that stepchild relationship ceasing, they are no longer cis dependents. And yet we do see many clients, particularly in my practice, where they've nominated a stepchild that's been in the family for many, many years, and quite naturally are considered the same as their blood-related children. But for Cis Act purposes, upon their death, that relationship ceases. So if their spouse who survives them have also nominated that child, they're no longer a cis dependent. So you could have unwittingly an invalid nomination, and then the question becomes, well, is the nomination wholly invalid or partially invalid? If there are people that are eligible and some are not, what does that mean? And to date, we haven't seen any clear case law on that issue.
Yeah. And therefore, when we look at SMSS, one of the findings, I guess, when we look at documentation here is that there is our payment standards and what we need to follow in Section 59A of the CIS Act and in the 617A of the CIS regs. But SMSFs don't need to naturally follow those requirements. Rather, we need to look at what the governing rules of the fund say. And we've got SMSF Determination 2008-3 give us the guidance that really open up the planning opportunities and the way in which, therefore, the deed needs to be constructed to enable a death benefit nomination to achieve outcomes that particular members would want to see.
Yeah, and indeed, both the ATO in that determination and in more recent case law, the courts have made it very clear that for an SMSF, they don't have to follow the prescribed form of binding nomination in the CIS Reg 617A. So it's open for any fund to write its own rules on how a binding nomination is to be made binding. And so, as you point out, that highlights the importance for advisors, particularly to be acutely aware of what the deed says on how a nomination is prepared and indeed how it is signed.
Yeah, and that's followed due process. And we regularly see, Chris, where there may be a requirement for that death benefit nomination to be accepted. So that may need some minute or resolution. And if, again, you haven't got due process, it could come into question whether that nomination was, in essence, a valid nomination because whilst it had followed the requirements of the deed, the fact that it wasn't ultimately accepted by the trustees means that it wouldn't come into force anyway. So there are a range of processes and stuff that practitioners really need to be acutely aware of and be looking for inside the deed to ensure that, you know, if it says you got to jump a hurdle, do a backflip off the table before it can be accepted, well, they're the things that you actually have to do.
Yeah, and I think the case that we saw last September of last year, the Cantor management case, acutely highlights the importance of making sure what the deed says as to how a nomination that is indeed signed is actually made binding.
Yeah, yep. And so therefore, when we think about the greater flexibility that is offered to an SMSF around the construction of the death benefit nomination, what are some of the things that practitioners and trustees should ultimately be looking for in the deed to allow for that death benefit nomination to be created? So I'm thinking here like step nominations, the lapsing or non-lapsing nature of them, and so forth.
Yeah, that's a good question, Aaron. I think a death benefit nomination is like the proverbial shoe and foot. I think it's very important for advisors to ensure that the nomination meets the client's requirements. Now, the standard nomination required under CIS Reg 67NA, which is, quite frankly, in most deeds of Australia, as just a recitation of a form of nomination, in my view, is wholly inadequate because it just stipulates the percentage of a member's death benefit and who it's to be paid to. You touched on the question of step nominations, and I think for our listeners we should perhaps clarify that. A step nomination is where you say if in first instance your nominated beneficiary is, say, your spouse, the nomination would specify if your spouse should die before you, who is to receive the death benefit. Now, that's really important, and that's missing in the standard form of nomination that's in 617A and in most deeds around the country. And that can cause catastrophic consequences. So, for example, if you've got mum and dad who have a single car accident and they both die together, and they have a standard nomination that nominates each other and to receive their death benefit, on the death of both of them, if there's no step nomination, you have no binding valid nomination. And what that would mean is that the executor, most likely, of the younger of the two, because under the laws of succession, it's presumed that the older dies first, the younger of the two would jump into the saddle as replacement trustee and exercise a discretion to pay a death benefit, well, like we saw in Katz and Grossman, to themselves. So step nominations, in my view, are critical to ensuring that clients' wishes are made effective.
Yeah. And even in a very, what I call vanilla mum and dad scenario, it would be, dad to mum and then mum to the legal personal representative.
Exactly.
But it provides that definitive stepped process or cascading in terms of what happens when one party dies, what has to happen next.
Yeah, and I think the point you're making is just one of certainty. What I think most clients want is they want to know that there's some control of where their money goes when they die, and when their spouse dies, that it ultimately goes to their beneficiaries. So, yes, I think for mum and dad, for most people, they would nominate their spouse, and then if their spouse predeceased them, then their LPR, and then their will would then cash out all the super, or the super would be cashed out to the estate rather, and then it would distribute it to children, grandchildren, or other beneficiaries. And that's quite a simple process, but I think it's important, because without a step nomination, if there was conflicts in the family, particularly with blended families, you could have a disastrous outcome.
Yeah. And one of the things with the super reforms has obviously highlighted the importance of these estate planning issues. And one of the concepts that we sort of thought through and have now incorporated into the deed and very much relates to this topic is the concept of a paramount document. And we've brought this into this process or decision-making process of binding death nominations as we have with reversionary pensions. Do you want to maybe elaborate on why we think this paramount document becomes so critical with the introduction of the new super reforms?
Yeah. Yes, that's a very good question. It's a big topic. What we've seen with the reforms, as we all know, is that if someone has got if a member who survives the death of another member in the fund is going to receive an excess total superannuation balance, then there has to be a compulsory cashing in or cashing out of the fund of any excess benefits, assuming that the surviving member cannot roll back any existing retirement phase income streams, or if they're in accumulation phase, they can't receive any more than their total superannuation balance. So what we're going to see moving forward with many clients is some money reverting to the survivor and excess balances coming out of the fund. So you're going to need to have clients complete a binding death benefit nomination that will deal with excess balances and a reversionary pension for non-excess balances. So we're going to see multiple documents that need to be prepared, and we're also going to have potential conflicts between documents if we don't specify which takes priority. So the idea of the paramount document concept is to really put some priority on how benefits are to be distributed or dealt with, particularly if there is silence or inconsistency in the way clients have got transfer pension amounts that are reverting or non-reverting.
Yeah. So when they're tested against their transfer balance cap, the big issue, like you touched on there, is that you could have someone that already has reached their $1.6 million cap, for example, and is to receive money as well. They may decide to roll back part of their interest. Now, on the basis that it was all in pension phase, they may have been solely relying upon the fact that they had a reversionary income stream in place. and relying on the fact that it would continue on to their spouse. So if they don't have a death benefit nomination in place for that accumulation interest now, there's no way in which that benefit would be dealt with, as opposed to potentially where they were relying on the auto reversion of that income stream. So we need to look at both the death benefit nomination and the reversionary pensions very much in tandem when we have these issues being confronted. But like you said, the paramount document concept gives us some certainty as to which one we want to take precedent, in particular where there may be some dispute or inconsistency in that approach. And it's not uncommon, I should probably say, that we see an inconsistency in terms of what may have been documented by an accountant, a financial advisor, that the pension is to revert. But Chris, you may go and see someone and quite clearly the way in which a death benefit nomination might have been done is clearly not aligned to what the interests of that would be. So when push comes to shove, if we don't have any form of definitive outcome, well then, what one is going to take precedent, we may have to go back to the deed and reference, what one would actually take place in that circumstance.
Yeah, and I think there's another issue too, Aaron, and that's this. As we know, as from the ATO perspective, if you've got two members that are in pension phase, or let's say retirement phase, or receiving retirement phase income streams, and if the member who is dying reverts their pension to the other spouse, and there's going to be an excess transfer balance.
Yep.
From the ATO's perspective, there's a choice. The choice can be that the receiving member can roll back any excesses to accumulation phase, or cash out of the fund. Now, we might have a client who says, look, I don't want to give them that choice. I want to have the choice where that excess goes. I want it to go to my estate, maybe for the children of another relationship. I don't want my spouse, with all due respect to her or him, to make that election. So we may want to specify, for example, a non-reversionary pension up to the transfer balance, or up to the transfer balance cap, and any excess be paid pursuant to the death benefit nomination. In other words, we want to remove the choice by the surviving member as to how that excess is dealt with. Well, we can do that with a binding death benefit nomination, and if we make it a paramount document, the trustee then
is bound by that decision.
Is bound by that decision in respect of the excess.
Correct.
And that excess can't be determined because obviously at the time of death, the member, they may have spent their they may not have an excess, or their spouse may have inherited money or rolled over other benefits. And we may want to regulate, or the member may want to regulate where that excess goes. Now, for most people who are in non-blended families, they may be happy to leave that choice to their surviving spouse. But for a blended family, it might be different. And so this is where the binding, the paramount document can work very well in regulating those excesses, particularly in conjunction with a binding death benefit nomination.
Yeah, and that is very much the reason why when we started making the updates to sort of February, I think it was, last year, and started to identify the importance of these issues coming about. And I think only now, as practitioners are working through and revisiting all these transfer balance cap issues and so forth, that these issues are going to start to rise to the top in conversations with clients, because we are not only are we seeing deed upgrades and the fact that we need to make sure that we comply with a lot of the new measures that are coming in place, but now we're going to need to make sure we go back and ensure that death benefit nominations are done properly, or whether we want to have that as binding or non-binding, or lapsing or non-lapsing, or whether we have an SMSF will, for example, as something that's going to be important that covers off the instructions that individuals need on an ongoing basis.
Yeah, and I think it highlights all of these reforms highlight the need for flexibility in their deeds, and that's why, as you point out, Aaron, we sat down again with Ian Glenister and the three of us. We really thought through the importance of the deed having maximum flexibility to deal with the unique client circumstances, to address these sorts of issues of excess transfer balances, potential conflicts in documents, and making sure that the money ends up where it's supposed to at the right point in time. And I guess this also underscores the importance of advisors having some sort of discussion with their clients about their estate planning, because often, as we'll see with excess transfer balances, it's going to flow into the estate probably a lot earlier than what would have been the case prior to the reforms.
Yeah, absolutely. I couldn't agree more. So, and I think just in closing there, the guidance, what other, I guess, any other guidance that you would have for, accountants and planners? You obviously work quite extensively with them around this process. Is there any, I guess, things that most importantly you think that they should be looking out for, or the way in which they should be engaging with their clients and solicitor in terms of the preparation of this type of paperwork?
Well, I think we've made the point that they need to understand and read the deed. That's the start here. The Cantor case, which I alluded to earlier, was simply one really about whether the nomination was given to the trustee for it to be made binding. Now, our deed doesn't require that, but some deeds do require that, and that's a hurdle. So if the Cantor case really focused on what was the form of service of the nomination, and whether it was made under the Corps Act or whether it was validly given. Fortunately, in this case, it was effectively served. I think it was served on the Office of the Accountant. But if it wasn't served at all, according to the judgment of that case, it would be invalid.
Invalid, yeah.
So I guess, it underscores the importance of understanding the deed. This is all black letter law at the moment. There's no discretion to the court to waive these sorts of requirements. Fortunately, the deed and the binding nominations that we've written give a lot of flexibility to advisors to get this right, and to also add value to clients. I think that's the key point of all this. Is a binding nomination is not just a bit of paper that says where their super goes. It actually encompasses a consideration of the client's wealth and when it goes and how it's distributed. And you alluded to the SMSF will, which can deal with in-specie asset transfers. That's another really important issue that we see with particularly family businesses, where there's business real property and one of the children are working in the business, and mum and dad says, well, look, I want my son who's running the business to get the factory. We can do in-specie transfers, and we can consider the impact of that with other assets and so forth. So it really gives the advisor the foray and the opportunity to add more value to their relationships with their clients, and to demonstrate their skills in this area.
Yeah, and so I guess what we've seen is the importance to really take a strategy-based and risk management approach to the way in which the deed is constructed, and that's very much the part of what we've spent time, effort and energy in building in there, and the flexibility in the nomination, to be binding and to be lapsing or non-lapsing. Some of that flexibility we're built into it. We've spoken about the ability to not only look at it in percentage terms but dollar terms, and be somewhat more prescriptive than we ever have. And then I guess the next step is to then go, well, do you need to be even more prescriptive in terms of how an SMSF will would actually play out as well? So I guess the best piece of advice is be very clear in terms of what the deed requires you to do, because the courts will take a very process-driven approach to work out whether it is valid or not as well.
Yeah, absolutely. And the Cantor case is just one of a series of cases where the courts are just saying, what does the deed say? And if it has it been followed, and if not, it's not binding. If it has, it's binding, and it's black letter, simple.
Yeah.
And it's so on that point, it's easy for advisors to get it right if they just follow the process, but it's also easy for them to get it horribly wrong.
Yeah.
They're not aware of what the deed says, but. Obviously, with the sort of programs and seminars you're running and the education that's available through the Academy, that's going to add a lot of value and support to advisors who tremble maybe in this area, but there's a lot of resources available and there's a lot of flexibility available.
Yeah, Yeah, absolutely. And we work together closely, like I said, in terms of not only the construct of an ongoing construct of the deed, but with yourself and Ian, you do a lot of work supporting our members. So if you do have any questions to any of our members or those that use our platform, people like Chris are there, of course, to support and provide that legal background. So Chris, thank you for your time today. We're going to have several discussions, I guess, upcoming. We've got plenty of things that we want to be talking about, not only, I guess, SMSF specific, but in terms of what we've done in terms of how the deed can really help benefit practitioners out there. So thank you very much for your time today.
You're welcome. Thanks, Aaron, and good afternoon, everyone.
All right, thank you for joining us today, and I look forward to you joining us for next week's podcast. Take care and have a great day. Bye for now.
Thanks for listening to the SMSF Academy podcast. Please note that the podcast provides general advice only and is based upon our understanding of the law at the time of the recording. If you have any comments or questions from this podcast or wish to subscribe to the series, you can find us at thesmsfacademy.com.au. Tweet us at the SMSF Academy, like us on Facebook, or connect with us on LinkedIn.